questions can ask them at the end. We're going to leave a little bit of space toward the end. But anyways, my name is Anwar Ramirez. I am a business and immigration attorney in Oakland and in San Francisco. I've been working with LCCRSF now for a few years, primarily because I'm aligned with, they have great staff, but I'm also aligned with their values, which is racial, economic, and immigration justice. I believe that by empowering diverse members of our community, and I think LCCRSF shares this with me, we contribute to a better, well-rounded community and a stronger society as a whole. LCCRSF is a valuable resource with very competent staff. And for all you entrepreneurs out there who are looking to improve your business or expand your business or just have questions, I encourage you to reach out to them. They're an incredible resource. So usually we would hold this type of workshop for entrepreneurs who are looking to form or draft a transition plan in general, which is great governance. Every entrepreneur should do this. Usually they do this when a business owner becomes incapacitated or they're dead. They're no longer running the business. But this particular workshop today is within the context of immigration and certain entrepreneurs who may feel unsafe because of the current climate in immigration. DHS has taken a very aggressive approach, a very aggressive posture toward the immigrant communities, and whose only crime really is just being here without authorization. These are entrepreneurs who have formed businesses like yourselves, who are contributing to society, who have families, or maybe they don't have families, but they have formed a life here, and they're contributing to Social Security, they're contributing to their communities, and we want to ensure through this workshop that first of all, that you feel empowered to do something in case the worst happens, which is obviously DHS coming knocking on your door. There's a whole different course to that of how to deal with that. There's a whole different sort of educational body as to how to deal with your civil rights, and all of you have civil rights. But for the context of this workshop, we're going to be talking about business transition or business succession plans or transition plans for entrepreneurs whose status may be somewhat in limbo. Okay. So a disclaimer, every entrepreneur, every person has a unique set of facts and circumstances. This presentation is intended for informational purposes only, to give you a general overview of some key tools that I personally believe every entrepreneur should adopt into their business plan. Strategies that can just put you in a position to succeed. But for personalized guidance, we strongly encourage you to speak to a qualified attorney or to reach out to a staff member or to LCCRSF, and they can give you some guidance or provide you the resources or give you the advice that you need. Okay, so if you're looking for advice for your specific business, please speak to someone, an attorney or LCCRSF for that advice. Okay, so let's get started. These presentations can sometimes feel like you're drinking water out of a fire hose. There's just so much information and coming at you all at once within an hour. And the reality is that all of us have enough on our plate. You guys are family members, you're business owners, you have a lot to deal with. And my job here today is to not complicate your lives with legalese. It's to simplify your lives by giving you a very simple, basic overview of tools that are available to you, just so that you know that they exist. And if you want to uh, pursue or one of these tools or to learn more about it, then you can go ahead and speak to LCCRSF or an attorney. Okay. So, and obviously, I'm here to answer some of your questions if we get to that point. But I'm going to share a very basic PowerPoint presentation that I created in this week. It's a little bit kind of pathetic, actually. I'm not great with presentations, but this should be. I don't know if you guys are able to see this or not.
Yes, we can see it. And if you wanted to be in presenter mode, yeah, there you go.
Perfect. Okay. So again, very basic, very basic tools. Okay, guys. I just want you guys to understand what they are, and then we can get into the specifics. I can show you examples of what a power of attorney looks like, or what a revocable trust looks like, or what some specific provisions for business succession looks like. But the reality is, and it's my experience, that I can show you all those things all day long, but you're not going to get anything out of that. It's better just to give you an overview of how these things work. Okay. So these are it. These are the three tools, and there are more tools available to you, but everyone should have at least a power of attorney. Okay. Specifically related to your business. The revocable trust is optional, but you could also look into that. And I also believe that everyone should have some kind of internal management document, for instance, an operating agreement or bylaws or a partnership agreement for a succession, as a succession planning clause in case something does happen. Okay, so one in three, in my opinion, should be mandatory for good management of a business, or what we call good governance of a business. Two, revocable trust, that can be optional. Okay. So, what is a power of attorney for businesses? And I'm just going to read this with you and then we can discuss it. Okay. Uh, these are very simple definitions, so I'm not going to belabor this, but it's a power of attorney allows you to authorize somebody that you trust, somebody who you trust, to step into your shoes and manage your business if you're suddenly not available, whether it's due to detention, whether you're detained in an ICE facility, whether you're removed from the country unlawfully, or you're allowed, maybe you're traveling outside of the country and you're prevented from coming back in. That means you won't be able to directly manage the business. Who's going to step into your shoes? Or in any other kind of emergency. So, how do you form a power of attorney? A power of attorney is a relatively simple document, but the powers that you designate to the person who you trust can be many, or it can be limited just to one thing, for instance, right? So under Probate Code Section 4121, you can create a power of attorney where you say, I, Anwar Ramirez, designate my best friend who I've known my whole life to act as my agent or as my attorney in fact, right? An attorney in fact is a term of art. It's not really an attorney per se, but they act as your attorney in fact, or they can act as your agent to transact certain business, right? I authorize this person to act as an agent of my business, and the powers that I want to authorize this person to have, and then you list them. I want this person to manage my business. I want this person to sell my business in accordance with the following requirements, get a business valuation by three independent valuators if it's a really expensive business. I authorize this person to sign a lease on my behalf, to sign leases, to sign loan documents, to sign bank documents, or whatever. We can talk more about this because there's sometimes different agencies require different breadths of power of attorney. Okay, different requirements, specificities, right? And so you need to name somebody to act as your agent or as your attorney. In fact, you need to state what those specific powers are going to be. And you need to, I would recommend that everybody notarizes one. You have to notarize it. Specifically, especially, they're going to be acting on your behalf with a financial institution. Banks are very particular as to the types of power of attorneys that you can have, that you need. You're always going to need a notarized power of attorney with a financial institution, usually. I mean, all the ones I've dealt with require a notarization or two witnesses. But then you need to bring the witnesses in, maybe to testify, or you need to get their information, and it just makes it a little bit harder, right? So a notarization, and then why does it matter? Because without a power of attorney, you're not going to have clarity as to who's in charge. Maybe you have, maybe you're a parent, and maybe you have three children, but only one, I think I gave this example to Anna, but you have one child who is very business savvy, and the other two kids are just, they're just hanging out, maybe playing video games, they have no interest in your business. But all of a sudden you're missing who's going to take charge. If you need to have two things: clarity and accountability. Clarity, who's stepping into my shoes if I'm not here. So let's see here. So what do you need to do to form a power of attorney? I already talked about this, but you need to choose someone you trust completely to act on your behalf. Okay. Or on behalf of the business. If the business is a corporation or an LLC, that person is not going to act on your behalf. That person is going to act on behalf of the business, what's best for the business. So you need to state here, what is the power of attorney for? Is this to step into my shoes as a business manager? And in doing so, then they take on all the fiduciary duties that you then had. Or is this, maybe there's two partners in a business. Is this to act on behalf of you? Obviously only you, not your partner, right? So, and are they going to get along, the other partner and the person you designate? Are these people competent to act or to manage this business? Do they know enough about the business? What do you want to give them access to? So you have to completely trust this person, not just as your BFF, your best friend, but also as someone who might be competent to run the business. Get it in writing, write it out, notarize it, and then be very specific. This is where, if you could probably learn how to draft a power of attorney, all of us can. It's not a difficult thing per se. It's not a difficult document to learn, but an attorney can really help you in defining what it is that you want that person to have access to, or what limitations you want them to have access, to have. Maybe I recently spoke with a business owner who has a barbecue franchise in the East Bay, and the business itself, like, the tables and chairs, the assets of the business are not really they're that valuable. They're not at all. But the intellectual property, the sauce, the barbecue sauces, the specific sauces, that's valuable stuff. So do you want them to have access to that? Maybe, or maybe do you just want them to manage the business until until maybe you are able to come back to the country or able to be released. Uh, what about taxes? Maybe it's your CPA. Maybe you want to let your CPA know also that you have this power of attorney or this person, is going to be acting on your behalf. And then this is really important. When does this power of attorney become effective? Usually, a power of attorney is going to say, I grant these powers to this person effective on this date. And this power is only revocable if I draft a superseding document that revokes this power. So when does it become effective? For this particular case with undocumented immigrants who could be removed from the country, one of the considerations that lawyers are considering is, does it become effective? Does it spring into action when something happens? Maybe it's not effective today. Maybe it's effective when something happens, when that person is detained. So would you need a detention order? And then you provide that detention order, and then that person who is your designee shows that order and says, look, this is now effective. And then that person then has to draft a declaration saying, I have been designated to be a agent of Mr. Whomever or Mrs. Whomever with this power of attorney. This is a springing power of attorney, which means it becomes effective when this person becomes detained or removed or whenever. And this is the document I have to show that. And therefore, this is now effective. That complicates things a little bit. My recommendation is irrelevant, really, because all of you have your own specific circumstances. But if I have to recommend something, I would say make it effective now, and then just keep it in a safe place that maybe you know where it is, and you can tell someone where it is. And if you're missing, that person can come and get that document, and also make a reminder to yourself that to revisit this document every year. Maybe your best friend whom you trusted today may not be around a year from now. Or maybe you guys are no longer on great terms. So make sure you revisit that every year to make sure you still feel the same way about it. And some of the conditions for a springing power of attorney are an expedited order of removal. Maybe ICE comes to your home, knocks on the door, and gives you what's called a notice to appear. It says you have to appear. We're going to take you into custody. And the bond, the bail, is set at a certain amount, let's say $10,000. Your family pays for it, right? But now you have an order of removal, and now you have to deal with that. Or maybe, a notice to appear, or maybe you're just removed. They give you an order of removal. So when does it become effective? You have to speak to someone about when it does. And like I said, it becomes complicated because does removal mean detained? Does removal mean deported? Does it mean voluntary? All these things. So maybe it's better just to have it be effective from the moment you execute that agreement. So that's a power of attorney. And in my opinion, if you really feel that your situation is at risk and you are at risk of being removed and losing control of your business, you should probably have something like this. Okay. Save your questions for the power of attorney. We're going to come back to that. Okay. Second thing, this is called a revocable trust. This is the second tool. So what is it? This is a more sophisticated document than a special power of attorney. Oh, by the way, when I say power of attorney for business purposes, I'm referring to something called special power of attorney or a limited power of attorney. It's not a general power of attorney. So the person whom you're giving this power to cannot make decisions, for example, unless you want them to, right? As to your medical, whether to pull the plug in case you suffer a stroke and you're on a hospital bed. Can they make decisions for your related to your medical care? Probably not, right? This is just for the business. So it's called a limited or a special power of attorney. Okay. Different from a durable power of attorney or a general power of attorney. Special, limited. Okay. That's what we're looking for, just for business purposes. Revocable trust, more sophisticated. Like I said, this is a legal tool that allows you to transfer ownership of your business and other assets into a basket we call a trust. And then you control it while you're alive. So maybe your business is not the only thing you have as an asset in your life. Maybe you have a collection of, of cars, classic cars. Maybe you have a home, a single family home that you've paid for. Maybe you have a timeshare. I don't know. Maybe you have a vacation home, a cabin, or you have a collection of stamps that is worth, whatever, $150,000. Maybe you have a retirement 401ks. Those are usually designated who the beneficiaries are, so it doesn't really matter. But maybe you have a savings account. Maybe you have Bitcoin. All of those assets will be placed in what we call a revocable trust. All your eggs in one basket, right? Including your business. So, and the person, and how is it formed? It's formed, you are called a settlor, okay, or the trustor. And then you designate a trustee, someone who you trust, or again, another person whom you trust, right? To sort of manage all of those assets. What's going to happen with all of those assets, right? And then you designate a beneficiary. That beneficiary could be you, right? It could be someone else, but generally you, if you're not around or whatnot, yeah. And that property is conveyed to the trust. So, and the trust involved, if the trust involves real property, then you should get it recorded. And the short end of it, guys, is if you guys are going to put all of your assets in a revocable trust, you should do it with an attorney. You should do it with a lawyer, unless you're very savvy with these sort of instruments, then you can do it yourself. But this is one of those tools where you have to seek an attorney, okay, an attorney's advice or guidance. And why does it matter? Because if you own your business in your name only and you're detained or you pass away, it could be frozen in legal limbo. A trust helps avoid probate also. I'm not going to talk about probate, but probate can be an expensive process if you die, or if you die without designating what happens to your assets, then the state has to take over and manage those assets. And you don't necessarily want that because it can be an expensive process, especially if you have a bigger estate. It protects your business and you make sure that your people can care about and carry on. A preparing immigrant, in this case you, can place your business assets into a trust that in the event of detention can be managed by a trustee who will take certain actions to ensure that the owner's plans for business are carried out. So a trustee and an agent with a power of attorney, right? Power of attorney, you designate an agent or an attorney, in fact, and then a revocable trust, you designate a trustee. Two different, they can be, a trustee can also manage your business, but sometimes the trustee can just be someone who you trust, and that trustee can designate someone to, for instance, manage the business for you, for your benefit or for the business's benefit, in accordance with your wishes. And if you don't leave any wishes, the trustee has a lot of responsibility. They have a duty, a legal duty to act on behalf of the beneficiary. The agent in the power of attorney has a legal duty to act on your behalf. If they don't act on your behalf, they could be subject to legal repercussions. For instance, if they take something, if they embezzle money, that's effectively a crime. If they sell the business for $20,000 when it's worth $200,000, that's negligence, right? They should have probably had the business valued by a professional, by a valuation expert, a business valuation expert, rather than selling it as is, without doing their due diligence, right, as we call it. And so how do you form a revocable trust? Again, talk to a lawyer, but effectively what you're doing is you're transferring all of your assets into a trust, and then that lawyer is going to guide you and tell you how, what assets you need to have, or in how you, in what kind of maybe guidance you need to have for each asset, etc. Also, if that, let's see here. Oh yeah, this is the difference between a trustee is not always going to be a great business manager. So maybe you want to just tell him, in case you're not around or in case you're removed, to designate someone who's going to be somewhat business savvy. And you can leave it up to their discretion. But by then, you and the trustee will have communication, hopefully by telephone or other means, right? Even if you're in detention. Okay, so that's revocable trust. Save your questions for that. We're going to move on to the third thing, to the third tool, and it's 5:05, and we're going to be done with this very shortly, okay, in about 10 minutes, and then we're going to have about 15 minutes of questions, and I'm happy to go over that as well if need be. These are the third tool is succession planning clauses. These are clauses or articles, or this is language that you need to have in your current business documents. If you are a sole proprietor, in other words, you just have your own business, you don't have business partners, you can draft an operating agreement similar to an LLC. If you are in a general partnership, you should have something called a partnership agreement, whether you have one partner or two or three or four. And if you don't know what the difference between a sole proprietorship and a general partnership is, effectively, as soon as you start doing business with someone else, you start providing a service or selling a good with a partner with the intent to create revenue for a business, whether you have a business name or not. You have a business. You just created a general partnership. And if that person is sued, you can be jointly and severally liable as well, and vice versa. Okay. So you should have a general partnership in case there's a disagreement or in case you're no longer around, who's going to take your place. In the case of an LLC, you have a document called an operating agreement. In case of a corporation, you have a document called the bylaws. The bylaws will indicate what happens. How do you value the business? How do you sell it, right? So those three tools that I mentioned are going to be written documents that are going to tell the business owners how to run the business, or in case the business no longer exists, how, or maybe it goes under, how to sell the business, how to wind up the business, and all of these different steps. But why am I saying this? Because you can write in what you want to happen with your share of the business or your interest in the business. If you go into business with another person and you don't designate your ownership, by law, you are 50-50 owners. Okay, you share 50% of the profits. You also share 50% of the liability in case something happens, the losses, right? Profits and losses are equally shared. But in a partnership agreement, you can designate that, well, I put in $90,000, this other person put in $10,000 into the formation of the business. I should own 90% of it. This person should own 10% of it, right? That's one clause that you can have in there, like a division of assets or interest, right? You could also have a clause that if you're no longer around, or if you're missing, whether it's incapacity or death, or maybe you were removed from the country, and you can no longer participate actively in the business, what happens? Do you want someone else to step into your shoes? Maybe you don't. Maybe you're um, you do landscaping, and no one else is going to step into your shoes. So what you want is you want to sell your share of the business, and maybe the business is worth $150,000, and your share is 50%, that's 75%. So you to have a right of first refusal. So you want your partner to buy you out if you are no longer available. Or maybe you want your partner to buy you out, and then who do they pay? How is your share valued? Have you guys valued the business every year, recurrently, to ensure that the value is um, current every single year, right? Or how are you going to value it? These are all the things, all the specific sort of clauses that you want to include, whether you have a partnership agreement, whether you have an operating agreement, or the bylaws. And there's some statutory language that already exists, and a typical partnership agreement, for instance, right, that you can just use, and you can just maybe amend it to your liking. Why does it matter? Because obviously, if you're suddenly unavailable and there's no plan in place, your business could stall, your clients could walk. Maybe you have contracts with vendors, right? And your partners or family could be left in legal limbo. Succession planning allows your business to keep moving forward without confusion and conflict. Um, Confusion and conflict, that ties into what I said earlier about clarity and accountability, right? All legal documents should have those two elements. You want to be clear about what's going to happen with the business, who's going to take over, and accountability. If it doesn't happen, who's liable for that? These are some, like, so just examples, right? Management clause, like who's going to manage your day-to-day operations if you're gone? Who's going to have authority to access your bank accounts? This is something that you would probably want to file with your bank, right, to ensure that they have it, because they have all these internal forms. Financial institutions have internal forms, and it's best to do what they want. Otherwise, you're just going to you're going to be in bureaucratic limbo. It's very frustrating. What are the decisions that someone's going to make if you're not around, if you're not available? How long do they have, for instance, to sell the business? So what if you're just in detention for 2 weeks? What if you're in detention for one day? Can this person sell your interest in the business in that one day, or do you want to give it some time? Right? Maybe you want to stay. If a partner is unavailable to participate directly in the day-to-day operations of the business due to an immigration situation such as for 90 days or more, then this other partner can take action. But one day, it's unreasonable, right? So employment and role protections for family. Maybe you have a spouse, maybe you have a sibling. And by the way, a lot of these agreements, if you don't have a prenuptial agreement and your business is considered community property, your spouse may need to sign some of them as well, especially if it relates to selling of business assets. Obviously, tax compliance, who's going to file your taxes, renew licenses. You can imagine someone going in to renew your business license or your health department license with the city or whatever license, right? And it's a different person. That person is going to need to show documentation showing that they're authorized to take steps on your behalf. So yeah, so that's really it. I could show you examples, but I just don't think they're necessary. And besides, let's see here, actually, stop share. There we go. We're back.